All right, good afternoon. Welcome to the estate planning workshop. I'm Leslie Sultan of San Martino and Sultan Law Group, and we are going to do a workshop today. This is the month of June 2025, and we're going to go through the workshop. If you have your workbook, hopefully you've printed it out and you can fill it out as we go along. If for any reason you don't have the workbook, as long as you have a piece of paper and pen, you can still follow along and just kind of categorize your responses. The point of the workshop is to be able to almost like a mini consultation with an attorney, where you're going to be, I'm going to provide information on how to pick guardians, power of attorney agents. And if you fill it out today, you've saved time for a future consult with an attorney because you've already answered some of these questions and, thought about it. So we do encourage you to fill out the workbook. And then that will qualify you for a discount with us, which I'll talk about at the end. All right. So quick intro, I'm Leslie Sultan. I'm a working mom. I have two young kids. They're 8 and 10 now. I founded my law business in 2010, and just this year in 2025, I partnered with Christina San Martino, and we are San Martino and Sultan. And we take a very personal approach with every case we work on. Nothing's cookie cutter. No two families are the same, so no two estate planning. The estate plan should be the same. So we definitely want people to feel like they're, getting specialized attention and a personal approach for their estate plan. Quick disclaimer. This is San Martino and Sultan Law Group, PLLC. Our attorneys licensed to practice law solely in New York and New Jersey. The materials appearing in this workshop are provided for informational purposes only and do not constitute legal advice. You should not take any action based on this information without consulting an attorney. Nothing in this workshop should be taken as engaging or offering to engage in any activities in any jurisdiction where those activities would constitute the unauthorized practice of law or would otherwise be unlawful or improper. This workshop is not intended to create an attorney-client relationship. Okay, now that that's over, let's get to the fun stuff. So today I'm going to start with as if I'm speaking to parents of minor children. If this part doesn't apply to you, don't worry, it's just a few minutes. And then we're going to get into the larger, broader area. But I think it's really important that parents of minor children are thinking about estate planning, so I'm going to focus on this first. The main thing to know is that obviously if something happens to you, we need to have a plan in place for who's going to raise those children. If you don't have a plan in place, the court, a judge, is going to decide your children's future without any input from you. So estate planning can very easily nominate the person of your choice to be the guardian and raise your children, making wishes, based on what you think is best for them. So it's really important that parents of minor children are doing estate planning. So one of the things you want to think about is, and we talk about naming guardians, okay, that's the legal term for who would raise your children, is in the long term, trying to figure out who you want to do that. It can be a really hard decision. I'm not going to pretend that it's easy. But we do want people to think about it, right? And to make a plan. So, we're going to start with who can you think about when you want to raise your children? And most important is we don't want this decision to stop you from making an estate plan because it's a hard choice. It's better to have a plan in place and you can always change it than to not have a plan at all. Because again, then you're just in court and dealing, leaving it up to a judge. So we definitely want you to at least make a plan. We think having a plan is better than no plan at all. So in terms of how you're going to pick guardians, you want to consider the following. You're going to choose one primary. You can choose two primaries, maybe a husband and wife. And then, who would be backup? So if that person or that couple is not available, you want to have at least two options because if something happens to them, you want to know that there's somebody else in line. Who do you choose? You could do relatives, close friends. There's no restrictions. You just, you're choosing someone based on their parenting styles, their moral values, health, religious, whatever makes sense to you, who you would want to raise your children. Ideally, it's someone that knows your children, right? So it's not just some stranger that's very well, but your children don't. Consider where do they live, right? So if you're choosing your best friend, but they're in Colorado, what does that mean? Your kid's going to have to relocate? Is the Colorado friend going to move to New York? These are also conversations you're going to want to maybe have with the potential guardians. If you're choosing your grandparents, will they be around and able to raise your children or even your parents, right? So you want to consider the age of the potential guardian. Lastly, you want to consider, are they good with money? Now, to be clear, the guardian does not have to be the same person that you would pick to manage the inheritance for the children. So that doesn't have to be a factor. You can have your best friend in the world who's terrible with money raising your children and appoint someone else to be the trustee of the money for the children. Okay, so that's a big thing that we want people to know. All right, and then of course check with the guardians, make sure that they're okay with stepping into this role. Again, I always like people to know what would happen if they don't do the plan. So if you don't have a plan in place, there's something that's called a guardianship proceeding. This happens in the courts. The judge appoints someone who takes control of all the assets. They appoint a guardian for the assets of the inheritance, and a guardian for decision making. It could be a total stranger, right? Ideally, it's going to be a family member. But what if you have conflicting, your side of the family versus the dad's side of the family, and there's a conflict, right? They both are fighting over it. How does the judge choose? It can get very complicated. So if you've got a nomination in place, the judge is going to consider what you wanted as well. These court proceedings are also costly and time consuming. The courts have to appoint an attorney who is going to make decide based on the best interests of the children. It can just get really complicated. Knowing what could happen if you don't plan is really important as a motivator, hopefully, to do a plan. So here, if you have your workbook, this is where you would fill it out. I'll give you guys a minute. If you have children, just jot it down. Who would be your primary? Okay, number one, to raise your children. It could be a husband and wife or couple. And then if they're not available, you want to list a first successor, so a backup, and an additional backup if that person's not available, or those people. All right, and if if you're feeling nervous about making a decision right now, just make sure you do it before you schedule your consultation with us so that this information is filled out. Okay. Also thinking about guardians for minors on the short term. So for example, I have an aunt that lives in Canada who I would want to raise my children. But key language is she lives in Canada. So if something were to happen to me and their dad, and we are during the day and the kids are in school, the school has no one to pick the kids up. They're going to call the police. The police is going to call Child Protective Services, and the kids are going to wind up in foster care until the aunt can come from Canada and get them. Okay, and that could take a day or two, right? Depending on all the circumstances. So I do not want my kids winding up in foster care. But I can identify short-term guardians, maybe a trusted neighbor, a close cousin that can go at least pick them up from school and take them home or to my home until the aunt can come. So most people have people locally. So your short terms can be the same as your long term. But basically, we would prepare a document that says, I am nominating these people as short term guardians. And then they would be able to use that document to pick up the kids from school or camp or whatever it is. So you want to, again, pick 3 people, ideally, number 1, number 2, number 3. These don't have to be in order, right? The goal is to just get the kids safely home, keep them out of the foster care system until the long-term guardian can come. So I would suggest, picking 3 people that you trust, that know your children, that your children feel safe with. Obviously, it's going to be a traumatic time. We want it to be as safe as possible. And then also check with them, make sure they're okay with stepping into this role. So again, you want to identify local people as what we call short-term guardians that have the rights to pick up the children from school if something were to happen in an emergency situation.
Good girl.
I'm just going to mute Susan. All right. There's also a document that we can provide if requested called a guardian exclusion. So, is there someone who, under no circumstance, do you want them to raise your child? If so, we're going to create a document that says, I do not want this person to raise my child, and that could be presented to the courts. So, if something were to happen, you've got your primary guardians who you want, they would have this exclusion document that would let the court know, during my lifetime, I did not want this person, and I really want the court to take that into consideration. So again, if you have your workbook, here's where you're going to fill out your primary six. This is actually wrong. It should just be options 3, 1, 2, and 3. And then, the school or whatever would go down the list and call the first person who answers and have them pick up the kids. Okay, I hope I'm not going too fast for people. So now I'm going to move into the trustee section. So we're going to talk about trustees and executors. So this is more of the general topic for all of my attendees tonight. So what is a trust? A trust is a legal document. It's signed and notarized, and it goes into effect during your lifetime. It can take over during a period of disability, and of course after passing away, during afterlife. I don't know if after death. Okay. Because the trust is effective during your lifetime and you can change it, it's referred to as a living document. So you've heard the term living trust. All right. Now there's 2 types of trusts, and some of you may be familiar with these terms, but I'm going to just explain a little bit. So there's revocable and irrevocable. A revocable living trust is an agreement between the grantor, okay, the language here is the creator of the trust, and the trustee, the person who agrees to hold legal title to the assets in the trust and manage them. And the agreement provides instructions to the trustee as to how to distribute or manage the assets for the beneficiary. So while you're alive, you are in all 3 of these roles. You're the grantor, you're the trustee, and you're the beneficiary. So you can still manage all of your assets yourself, right? So you are writing checks for your personal account. When you put your assets into the trust and you're the trustee, you're still signing the checks. And you're also the beneficiary. So everything is intended for your benefit. This is great because in the event you become incapacitated, a successor trustee who you've appointed in the document can take over, but they can't distribute the assets to other people yet. They still have to manage everything for your benefit. And it's not until you pass away that you have essentially successor beneficiaries that get the distributions upon your passing. So most importantly, revocable trusts identify you as the grantor and the trustee, and then upon your passing or incapacity, successor trustees who can take over. Now with an irrevocable trust, it's a little bit different. So we're going to you're still the grantor, okay, because you're putting your assets into the trust, but you're giving someone else authority to control or manage your assets while you're alive. So now, once you create the trust, and that trustee has to manage those assets for your benefit. So you're still the beneficiary, but you're no longer the trustee. And that's important because of the benefits you can get from an irrevocable trust. So the one that we commonly use is called a Medicaid Asset Protection Trust. So I put my assets into the trust. Someone else is managing it, and because I no longer own or control my assets, I don't own anything. I qualify for Medicaid. And that's really important for people who have limited assets and need to think about long-term care and want to qualify for long-term care Medicaid, either in a nursing home or having the aides come to the home. If they're qualified, they get those covered, essentially for free. An analogy that we like to use for a trust is this little wagon. Okay, so you can see this girl, she's putting all her little toys in the wagon, and there's the handle that she's able to use to pull and control the wagon. She can take it wherever she wants. We call the trust a will substitute because it avoids the court process that I'll get into in a minute that is required for a will. So as long as the assets are in the red wagon, she has control, and whoever takes over the wagon later has control. And there's no need to go through the courts for that. If anything is left out of the wagon or out of the trust, then she's pulling an empty wagon. So we call this funding the trust, where you move them out of your name and put them into the wagon or into the trust, which allows you to control them and then your successor trustees to control them without ever having to go through the courts. So most important, you create a trust is the step one. Step two is funding the trust, is moving the assets into the trust. So if you own a house, right, in your name, you're going to do a new deed, usually through a lawyer, that says I'm basically transferring the house out of my name and into the name of my trust. Same with the bank accounts. You're going to go to all your banks and take them out of your name and your name's on the bank account and put them into a bank account under the name of the trust. And that's what allows the trust to control everything, which is exactly what we want to avoid going through the court process. So, benefits of a trust: it has all kinds of lifetime benefits. It provides for distribution of your assets upon your passing. It allows you to add your trust as a beneficiary on life insurance and sometimes retirement accounts. This is really important for minor children, right? So minors cannot receive a life insurance benefit if they're under 18. They can't legally fill out a claim form. And this is a mistake that sometimes people make as parents. And so what happens is the life insurance company has to will only give it through the courts. And this is a big problem because now the families are going through the court system in order to get the money for the children. And the courts then monitor this. And it's a big problem. It's very expensive. Lawyers, filing fees. I mean, it can get really ugly. I had a client who spent tens of thousands of dollars because her mother, grandma, left money to all the grandchildren and her child was under 18. So mom, spending her own money just to get the kid his life insurance benefits. So the alternative is you create a trust. The trust says I leave everything to my children, and then you name the trust as the beneficiary. Now, once the trust receives it, the beauty of the trust is it can say, I don't want them to get it at 18, 18 with no parent. They're young, right? We can change that age. We can say 25, we could say 30. There's a lot of flexibility that we can add into the trust. So it's really a great benefit if you have a trust to name the trust as the beneficiary, and then the children can receive through the trust. Again, another great benefit is a trust is an agreement. It's a legal document. It avoids court as long as all the assets are in there. Again, it provides for successors so that if you just name one beneficiary on an account, what happens if that beneficiary died before you? Are you remembering that and going to the bank and updating the beneficiaries while you're grieving? Maybe, hopefully, but if not, it's going to fail. And so now you're back in court. But again, adding the trust as a beneficiary, it prevents all of that. It allows for management of your property when you become incapacitated. I went through this personally with my mom. She had a trust and she lost capacity. She had dementia. And we were easily able to take over and help her manage all of her assets, which was a great benefit for us because it was hard enough taking care of her. Made it super easy for us to manage the money and pay her bills for her. You can always revoke or amend this easily. Trusts are easy to amend. You do an amendment. There's usually a fee associated with it, but it's better than a will where you have to revoke the whole will and do a new one. Now, trusts do cost more than a will initially, but as I'll explain in a little bit, wills get expensive because they have to go through the court system, and the court probate process can get very expensive. All right, so moving on to wills. So again, wills, what is a will? Most people know it's a legal document where you give instructions for how you want your assets transferred after your death. You can direct distributions of money and property. You can nominate guardians for your children. So no matter what, if you're doing a trust, we're still going to do a will, especially if you have minor children, so that we can, that's the legal avenue to nominate guardians as well. And then you nominate an executor who's going to execute the wishes that you put into your will. So for example, if you're married, you're going to nominate your spouse as your primary executor. If he or she's not alive, you might pick a sibling or a best friend. So um, that's, that's a will. Um, of course, you can appoint guardians. We went over that. And although it costs less to usually set up a will, there are costs, which I've kind of mentioned a few times now, with probating the will. So let me go over the probate process. So, if you're deciding whether to do a will or a trust, so one of the things to understand is the probate process. Probate means proving. In other words, a will cannot be, you can't take a will to the bank and say, hey, my friend just died, please give me all my money. The bank has no way of verifying if that will was properly done. They can't even know if you're dead, right? So there's a whole process set up just for this. It's the surrogates court, and it is solely for probating wills and estates. And this is where they have to authenticate the will. They have to make sure that it was done properly. All the people who were disinherited have to be notified and given an opportunity to contest the will. Yes, it's hard to believe, but yes. And more importantly, creditors come first before family members. So it's an opportunity in our economy, in our society, for people who die, for the creditors to come and collect their debts before the families get their money. So most people don't realize this as well. And then ultimately, the family inherits what's left. So in some states, I don't know where everybody is. I'm primarily New York, but we also do New Jersey. The probate process is quick. New Jersey is an example. You file a will, and usually within weeks, you get the authority to finalize the will and the wishes. In New York, unfortunately, that takes much, much longer. The average is around 6 to 9 months. So literally nothing can happen during that time. All the accounts are frozen. No houses can be transferred. If you have rental income property, nobody can collect rents. It can be very painful for family members, very frustrating. Nobody gets to receive their inheritance until that probate process is completed. Another thing people don't realize is there's costs involved. The surrogate court is the most expensive court. If you have, it's based on the value of your assets. So if the estate has a house, for example, it's valued at 500,000 or more, then the total, the filing fee is almost $1,300, $1,300. That's a lot of money. Now your family is paying to get this will filed, and maybe they want an attorney, so they're paying attorney's fees. The average attorney fee is around $5,000 for a probate starting. So now you're at $6,300 just to get this will through the courts. Not to mention all the time you're losing, paying taxes, paying bills, paying a mortgage until you can get the will probated. So the other thing I like to mention is probate is public. Okay, these are court documents. If you Google any celebrity who died, you can see if they had a will because it's public record, and the media hops all over it, and it gets all. So we say that nosy neighbor Nancy and evil predator Paul know exactly who gets what and how to contact them. Not everybody wants their information out there like that. So if you don't like the idea of having it be public, you definitely don't want to, you want to consider a trust. So again, deciding between a will and a trust, if you use a will as your primary estate planning tool and you own property in your name, you're going to have to go through the probate process. It's guaranteed. If you name beneficiaries on all your accounts that allow it, not all accounts do, you may be able to avoid probate because beneficiaries take automatically and they do not have to go through probate. So that is one way to avoid probate, is naming beneficiaries. But that's not always an option, right? So you can't name beneficiaries on a stock if you're a co-op owner. Some accounts don't allow it. Houses don't have beneficiaries. There is something called a transfer on death deed that went into effect last year, but it's very new and there's a lot of problems with it. So we are not yet recommending naming beneficiaries on a house through the current transfer on death in New York deed, but hopefully in the future that will be an option. But the main way to avoid probate is you create a trust as your main estate planning tool, and you move all your assets into the trust, and then probate is avoided. You save your family all that time and money. Again, I did this with my mom. My mom passed away this April, and I didn't have to go through court at all. All I had to do was write checks. So bottom line, how you decide, obviously everyone's family situation is different. It's important to analyze this with an attorney to determine what's right for you and whether nominating guardians, protecting your children's inheritance, and avoiding probate is added value for you and your family. So most people receive the greatest overall benefit from having a trust, but not everyone needs a trust, so it's really something you want to discuss with a qualified attorney. All right, so we're going to next go into picking, trustees and executors. So when you do that, you consider these factors. So you try to pick at least one primary and one backup, right? So if you're a married couple, you're going to have each other as benefit trustees, but who would take over if both of you pass away? And then if that person's gone, who would be next? So the more people you can appoint in the trust, the less you have to change it if something happens to the others. Obviously, it should be someone you know and trust, whose judgment you respect, and who you think would respect your wishes. Consider the candidate. Do they have financial savvy? Are they business, experienced with business? Are you leaving them a business they might have to run? You can choose your children, but they have to be over 18. And ideally, think about if you want your child to manage it. Maybe if they're too young, it doesn't make sense, right? If they're going to go off to college, it's hard for them to then be managing your assets if you're incapacitated while they're in another state going to college. So, these are not easy choices. I do acknowledge that. It's not easy to do this, but again, it's better to pick someone and put it down on paper and have it. You can always update it later. We just don't want these decisions to stop you from having a plan. There's an old saying, failing to plan is planning to fail. So we want everyone here to make sure that they've got a plan. So first step with your workbook is you get to pick a name for your trust. It can be any name you want. It doesn't have to be your name. Mine is called the Sultan Loving Trust. It can be the Golden Gate Bridge Trust. It can literally be any name you want. And then, of course, you want to just identify which type of trust you want, if you're going to do the revocable or you're going to do the irrevocable for Medicaid planning. So please fill that out. Okay. And then you're going to go to the next page or whatever where you're listing the trustees. So your primary, if you're doing a revocable, you're always the trustee first. But then who would be backup and then backup and backup? Same thing for your executors. So when we're doing a trust, we're also doing a will as a backup. We call it a pour over, P-O-U-R, because it pours the assets that were left in your name into the trust. Because the trust has all this magic language for minors, for what if someone's on disability. We don't want them to lose their benefits because they've received an inheritance. So the trust might hold the money for them. So that's called a pour over will. So we have to name executors. The executors can be the same as the trustees. The main thing I will say, though, is that the trustees should be U.S. citizens or legal permanent residents, because you don't want foreign, what we call foreign trustees, because it makes a trust, a quote, foreign trust, which gets taxed at a higher level. So if we want to avoid that whenever possible. The executor should also be in the United States with a legal permanent residence, New York, U.S. based. Otherwise, they're going to have to find someone else to co-execute with them. Okay, moving on, power of attorneys. So power of attorney is a really, really important document. I can't stress enough how important power of attorney is. So power of attorney is a document that gives your agent the authority to pay bills, make legal and financial decisions, manage investments, file tax returns, mortgages, sell property, buy property, anything legal and financial. That's done in a power of attorney, and it's usually used when someone loses capacity. stroke, Alzheimer's, dementia, any instance where somebody is no longer able to manage their own legal and financial decisions. Not having a power of attorney means that the court has to appoint a guardian for the adult. And you've seen this with like the Wendy Williams case, or the oh my gosh, I always remember, I forget her name, in California. Anyways, you've heard about this. When someone doesn't have capacity, the court has to appoint a guardian or conservator. These are awful cases. They're public. Again, I mean, there's some limitation, some privacy. There's a lot of people get involved. There's a judge, there's a court evaluator, someone has to be appointed the attorney for the alleged incapacitated person. People are looking through their finances and their house and their medical documents, and it's very invasive. So if you like your privacy, you need a power of attorney. But again, power of attorney is a very powerful document. So the person you're appointing can literally go into your bank account and withdraw all your money. So you want to make sure you're picking someone, that you trust, and you might not necessarily want to give them the document while you have capacity. So it's important to have it in place, but to keep it somewhere private just in case, So anyways, you'd want to have one primary and one backup. Most people would pick their spouses. Not everyone wants the spouse to be the power of attorney agent. So again, this is very personal for every individual. It should be someone you know and trust. It can be anybody over 18. And do talk to them about it. Make sure they know that you're considering them for this power. There's also something called a springing power of attorney, which means it only goes into effect if you've been declared mentally incapacitated. But this can complicate things. We don't generally do springing power of attorneys because I think it requires 2 medical doctors, and so then you're having to get someone evaluated, and what if you need to access the bank account sooner than that? So we do what we call general power of attorneys, durable power of attorneys. Okay, so if you have your workbook or your piece of paper, you're going to go ahead and list who's primary number 1 and who's going to be the backup. You can pick 2 people as co-agents. I just warn people, if you're going to do co-agents, that might mean they both have to sign checks together, right? They both have to go to the bank account to open the accounts. Are they local? Do they talk? Do they work well together? I've seen a family scenario where mom fell, she lost capacity, she's in a coma, it's been a couple of years, unfortunately. She had power of attorney with her 3 children, 3 co-agents. They worked together beautifully. It was wonderful. It was so nice to see that. That's not every family though. So if you're going to pick co-agents, you can either put, there's an option for that each one may act separately. Or if you're trying to, accountability, like I don't want my son to do anything without speaking to my daughter, then they have to work together. You just have to be aware that requires them to do all things together. And then of course you can have, if my son's not available, then my daughter, and vice versa. So you're gonna do primary and then the backup. All right, so we're also going to do healthcare proxy. We call them advanced directives or advanced healthcare directives. These are super important too. So where power of attorney is doing legal and financial decisions, the healthcare directive is going to give someone the authority to make healthcare decisions. And this can be as simple as you're in a coma or you're incapacitated. Can we discuss medical information with someone? So it can be the healthcare agent. This is important, for example, with college students, right? They go off to college, they're now over 18, they're autonomous individuals. If they're partying and they wind up in the hospital, mom and dad don't have, they're not allowed to get that information from the doctors. The doctors don't have the authority to share protected health information with them. But if the adult children signed a healthcare proxy and the HIPAA waiver and authorizing the doctors to speak to the parents, all problem solved, right? So it's these simple little things, these little documents that make all the difference when it comes to these awful scenarios. So a HIPAA waiver is the authority for the doctor to discuss medical information with someone else. The healthcare agent is also able to make decisions. We also have something called a living will, not to be confused with the last will and testament, which happens all the time. But a living will is where I am on life support, and the only thing keeping me alive is the life support. Do I want it withdrawn or do I want it to be continued? And so the agent usually has the authority to make that decision. But how do they know? They can look at the living will, which says if I'm in a vegetative state, pull the plug. I can tell you from personal experience, again, I lost my mom. I had to go through all of this. It was horrible. But again, my mom did all of these documents, and I had to make the decision to, essentially pull the plug. And of course, as a child and making this decision, I questioned, am I making the right decision? Is this what she wanted? And I knew in my head, I always heard her say, I never want to be a burden to the family, pull the plug. But it helped so much to see it in writing. It was right there and it said what to do. And so I knew that I could make that decision without ever having to regret it. So it's such a blessing that you can give to your family if you take the time to fill out these documents. Okay, so when picking an agent, obviously you want to pick number one and then have a backup. You can do your spouse. It doesn't have to be your spouse. And your spouse does also not automatically get this information. If you ever heard the case of Terry Schiavo, you could look that one up. But briefly, she, at a very young age, had eating disability and wound up having a horrible heart attack and was completely incapacitated. And her husband, she did not do these documents. And so her husband had to petition the court to be appointed the guardian. And it became a battle between her parents and him. And this went on for 7 years. And the woman was left on life support for the whole time because every time he would make a decision, the parents would appeal it. And it went back and forth for 7 years, poor thing, until finally all appeals were exhausted and he was finally granted the authority to pull the plug. So obviously having a simple document in place avoids that. So you want it to be someone you trust. Consider, maybe someone who's in your family that's a nurse or a doctor that, maybe they're not someone you would choose financially to make decisions, but you'd want them to make the healthcare decisions. And then, of course, talk to them. Make sure they know that you're considering them for this role. So if you have your workbook, go ahead and fill this part out. I was speaking to Audrey earlier on the call. She was like, what do I do when I have this document? Who do I give it to? So great question. You want to give it to the agent, right? Give them a copy so they have it. You can also give it to your doctors so that if you wind up in the hospital, if there's a record of who your doctor is, the doctor might have this on file. Usually when you go to like a procedure or surgery, some hospitals will have you fill it out anyways. But really important to have your own and to update it as you need. And again, HIPAA are people who can receive the medical information. So not necessarily making decisions, but you want them to have the information. End of life decisions. Okay, so do you want to be buried? Do you want to be cremated? Do you care? Is it up to your representative? If you have a wish, it's really important to communicate these things, and even more important to put it in writing so there's never a dispute. I can tell you, again, personal story, when I was 15, my dad died. But before he died, 6 months before he died, he had a heart attack. And so he was thinking about these things. And he sat me down, and I was 15. He said, I want you to know if I die, I want to be cremated. And I said, what's that? I didn't know what that was. And he explained it to me, and okay. And unfortunately, 6 months later, he died. And my mom said, okay, we're going to bury your dad. And I said, no, he wants to be cremated. And she said, how do you know? I said, because he told me. that simple conversation, and with a 15-year-old, who knew, but it made all, I knew that I was honoring my dad's wishes, and I want everyone to be able to feel that confidence. So communicate this with your family, your loved ones, make sure you know. And there's a form, it's called a remains agent form in New York State. And that's where you can appoint someone to make these decisions for you. They are authorized to say whether you're cremated and buried and where you're cremated and buried. Also taking an opportunity to prepay for your funeral if you haven't already done one or you're thinking about it. A friend of ours, Lindsay, I met with her today, and she reminded me how important it is to consider pre-planning for your funeral, because guess what? If you prepay for your funeral, sometimes you get a discount, and you can make payments, so you can pay over time. When you die, your family is stuck with a huge bill that they have to pay right away. And remember, if there's a will, they have no access to your money. They're paying out of their own money. So you could do a big service benefit to your family if you prepay for your funeral. Make sure they have that information, prepay for your arrangements. It's all done for them. All right, so you get to decide whether you want to do those things and then let the person know. And then again, with the living will, you choose whether you want your life prolonged, doing uh, you know, fluids, IV fluids, ventilators, or whether you want to be cut off. So if you have your workbook, please make these decisions. Um, and I'm going to keep it moving. Okay, so now real quick, we're going to get into, okay, well, what do I do with my assets? So generally speaking, there's what we call the residuary clause. So where residuary is everything. So you can say, I leave everything to my kids, divided equally. And if they're not alive, to their kids. But you can also do specific gifts. And specific gifts always come off the top. So it's important to know that. So if you wanted to say, well, I want my church or my temple to receive $10,000. Okay, assuming $10,000 is worth $10,000 when you die, that's going to come right off the top. So if you have $100,000 in your bank and you wanted to go to your children, they're only going to get 90 because the first 10,000 comes off the top. So you're going to specify that first. So you say, I want my jewelry to go to this person. You can get as specific as you want. And then any specific gifts go first, and then everything else goes in what we call the residuary clause. The other thing to consider is, okay, what if that church no longer exists? Who gets that 10,000? Okay, so if it usually goes back into the residuary, or you could say, I leave this to my sister, but if my sister's not alive, then to my brother. Or I give some money to my friend if she's not alive, to a charity. Okay, so you have all the varieties of options there, but you have to put it in writing. You have to be specific. So we always encourage you to have backup beneficiaries. So who's going to receive first? If they're not alive, then who gets it next? Okay, so make sure to fill this part out. I'm not going to do that in this part of the workshop, but this is important to fill out before you come to the next step of estate planning. All right, so we went over this. In the unlikely event that your beneficiaries are not able to receive, you want a backup beneficiary. Now, to be clear, if you don't specify, it's okay, but it's going to pass through the laws of the state that you live in, with your primary residence. So if you leave it blank and that person's not alive, if you say, I leave everything to my one child and that one child's not alive, then the state will take over, the state laws will take over. So it'll go to your spouse. If you have a spouse, it'll go to your parents. If no spouse or children, if no parents, it'll go to your siblings. If no siblings, it'll go to your nieces and nephews. And there's this whole hierarchy system. You could Google what the state laws are. So it will go to someone eventually. But if you want to control it and make sure it's not your random cousin that you haven't ever talked to that lives in another country that's going to complicate everything forever, then you have to specify. All right, so if you have any questions, Anything notes you want to jot down, please jot them down in this section. And I'm going to go on to the last step of this workshop. Thanks for hanging in there with me, guys. Okay, so what does our estate planning process look like if you were to come to hire us? We first have what's called a family planning session. It's an opportunity for us to get to know you, you to get to know us. We can either do these in our office or virtually through Zoom. We ask you to complete what's called an asset inventory spreadsheet, and so you list all your assets there, and that allows us to know what you own and make sure nothing's overlooked. An important example is, like, again, in New York, we have a lot of co-op owners. Co-ops are very complicated when it comes to trust. Literally, the co-op has to approve the transfer of the assets to the trust. So the first thing when we see that someone lives in an apartment, we ask, is this a co-op? Okay, before we go any further, contact your management or your board, make sure they allow a trust. Because if they say no, we want to consider different planning options. So, we want to be informed. We always make sure, you know what happens if you don't have a plan, what happens in your specific family scenario. If you don't like that scenario, then we have to design an estate plan for you. All of our estate plans are done on a flat fee basis. We tell you right then and there, so you don't have to worry about hidden fees coming up later, being billable hours. I've had to hire an attorney before at billable hours, and it's it's not fun. It's always higher than you expect. So we cut that process out. Everything is flat fees. All right, so stage 2 is drafting. So after we complete the family planning session, we schedule a signing date, usually about 4 to 6 weeks later. And then we start drafting all your documents. And about a week before, we send them to you to review via email. Once you review them, we make all the requested changes, and then we print them out for you to sign. At the signing ceremony, we have an in-person meeting where we go through the binder of all your documents, and you sign them. Some have to be notarized. Some have to be witnessed, 2 witnesses usually. And we hope that at the end of the meeting, you feel a tremendous weight lifted from you and a feeling of accomplishment and peace of mind that you are protecting your family. And that's our favorite part of this process. Once that's done, we scan all the documents so that we have copies. We record any deeds that we're transferring out of your name and into the trust. We hold everything until the deeds come back, and then we give you all of the documents. We also provide you detailed instructions on how to transfer the assets into your trust. And then we like to check in with you to make sure that you are retitling the trust, because the trust can only control what it owns. So if you leave anything out in your name, we're back in probate court. So unless you've added it as a beneficiary. So we really want to encourage and make sure that you're retitling everything. And then we encourage you to contact us every 3 years for a free review to make sure nothing has changed with someone divorced or their new grandkids. Whatever needs to be updated, we want to make sure that we are updating it. Sometimes we have people come in with like 30, 40-year-old wills, and it's like, gosh, good thing you came in because, so-and-so's not alive anymore, or, you don't want that person to inherit anymore. So it's really important to update your estate plan. I'll take any questions, but just Audrey brought up another question that we discussed before, and she said, where do I put my will or my legal documents once they're done? And one of the things we always tell people is do not put them in somewhere that's going to be locked and nobody can get access to them. One of the biggest problems that we've seen is people put their documents in a safety deposit box at the bank. When I go to the courts, the probate courts, one of the first things I see is a stack of papers that says safety deposit access petition. And so it is so common that the will is locked in a bank and nobody has access to it. And you have to go through the courts to get permission just to see if it's in there. And then you got to go back to the court to get permission to take it out. It's incredibly burdensome for the family. Don't ever do that. It's not necessarily secret documents, right? They don't necessarily have to be in lock and key. We recommend people put them in a fireproof bag and make sure that your loved ones who need to know where to find it. If you are going to lock it up, make sure they have the code or the key, and then make sure copies are available. So I'm going to stop the recording now and take any questions. And thank you guys for your time today.